Our tax code is improving. We are creating jobs, and I know we're going to move in the right direction here. So thank you very much.
Thank you for your comments today, sir. Again, you're right. That small business owner, I've often said, despite the best efforts of the local, state, and federal government, I've managed to succeed and keep my doors open. And again, it's amazing how many times people will tell me about business and what this law, that law does, who's never met a payroll, who's never had to stay up at night worrying how are you going to keep your doors open. And you're right, we are seeing small businesses and large businesses leave the state. There's several examples. So we are still struggling. But I'm glad to see that since I came in 2017, we have actually taken the corporate tax rate down. We went from 46th in the nation to 18th in the nation, made us more competitive. We have lowered the state income tax. And if you think that people say, well, Lauren, it doesn't mean that much. Let me tell you, look where the large CEOs these companies are moving to. They're moving out of state to a better tax rate. I get it. I see it. I don't plan on leaving Kentucky, but I have friends of mine that have, because of the fact they make enough money they can afford to do that. And we're never going to stop that until we become competitive. So if we want Kentucky to continue to grow like we want it to grow, we need to make sure we keep those people here. And just also for your information, I'm sure you're aware of this, small business creates 67% of all new jobs in the state of Kentucky. We are the economic engine. We are the ones who are creating jobs and making sure that families are fed and people have good paying jobs. Thank you for your testimony today, sir.
Thank you.
Next, we have House Bill 463. Would sponsor please approach the table? She wants to talk against it.
No.
That may be Judy right there. Please introduce your guests for the record, yourself and your guests for the record, please. Turn the mic on and pull it closer.
Thank you, Mr. Chair. Stephanie Dietz from the 65th District, and I will let my guests introduce themselves.
I would just like to go by Jen and stay somewhat anonymous because of the sensitivity of the story.
Could you pull your mic a little closer, please? And repeat that.
My name is Jen. I'd like to keep my name somewhat anonymous for the protection of my children.
Okay.
Good morning, Mr. Chairman. Christy Van Tatenhove, legal counsel to the Speaker's office.
Please proceed.
Mr. Speaker, or Mr. Chair, and members of the committee, thank you for hearing this bill today. With the passage of House Bill 463, Kentucky will join 12 other states in passing legislation aimed at protecting our children from online predators and exploitation that occurs from access to various social media platforms and has created a mental health care crisis for our children. Social media companies are providing a dangerous platform by establishing and creating endless content, failing to limit time limitations for children, providing intermittent variable rewards that create a rush of endorphins to the user. How many times do you check how many likes do you get on Facebook? Targeted algorithms, notifications of likes, filters, connection of child and adult users, age verification, and lack of parental controls. Our children struggle every day with anxiety, depression, self-harm, and suicide. And many would say, isn't this the job of the parents? We know that we have parents who are neglectful or incapable of monitoring and controlling their children, but even the best parents are overwhelmed by the technology that seemingly changes daily. As background, it's important that Section 230 of the Communications Decency Act was passed in 1996. The 1996 statute gives tech companies immunity for content posted on their platforms by third parties. This law was passed before modern social media. Many of you have seen the recent congressional hearings where federal lawmakers are evaluating the actions of companies like Meta, the impact of Section 230, and the potential need for reform at that level. While our legislative body cannot make changes to Section 230, we can pass a bill here in the Commonwealth that will protect Kentucky children from addictive and harmful approaches in the internal controls social media companies employ. In short, House Bill 463 establishes definitions for the types of social media companies covered and then sets parameters for those companies, how they must regulate the internal algorithms to protect Kentucky children and their private information. This bill has been a thoughtful process, beginning with the drafting in the interim, meetings with various stakeholders, including representatives from Google, Meta, the gaming and entertainment industry, educators, and many more. We considered what other states have done. We reviewed the court decisions that considered those bills. We tried hard to draft this legislation in a way that reflects a consideration of all these interests. What does this bill do? It establishes definitions for key provisions such as digital service provider, digital service, and verified caregiver. It specifies what entities are and what entities are not subject to the provisions of this bill. The provisions are meant to apply to social media companies or digital service providers whose platforms connect users in a manner that allows the users to socially interact with other users, allows a user to create a public profile for purposes of signing into the platform, and allows a user to create or post content that can be viewed by others. It places a duty to register the age of the user on the digital service provider. Social media companies are required to have users register their age upon using and creating an account. If the user registers their age at 18, the social media company is considered to have actual knowledge that the user is under the age of 18. A parent or guardian may also alert the social media company that the user is under 18 years of age, giving the social media company actual knowledge that the user is under the age of 18. It directs the social media company to duties relating to agreements with minors. A social media company must do the following with a minor: limit use and collection of identifying information, not allow the user to make purchases or engage in other financial transactions not protected by the First Amendment. For example, we would want our kids to be able to purchase a copy of the Bible online. We may not share, disclose, or sell the user's information. They may not collect the user's precise location date. They may not display targeted advertising. It places a duty on the digital service provider to prevent harm to known minors by focusing on their internal controls and algorithms. Social media companies must develop and must ensure that its internal controls are designed to prevent users under the age of 18 from being exposed to obscene matter. The digital service provider is required to create parental controls that allow a parent or guardian to control privacy settings and monitor and limit the amount of time their child spends on the platform. This includes temporarily or permanently deactivating the account. We've called this the parental kill switch. Social media companies must prevent advertisers from targeting minors with advertisements for products or services that are unlawful to minors. Social media companies must provide in their terms of service, privacy policy, or similar document information pertaining to algorithms, including how it promotes content. Provide common sense exceptions to when a social media company may share a minor's user's personal information. And we leave it to the social media company to come up with commercially reasonable method for verifying a parent or guardian. The verified parent or guardian may review, download, and delete any personally identifying information associated with the minor. And the social media company must establish a method for which a minor's verified caregiver can request access to the minor's collected personally identifying information. House Bill 463 is not a government initiative that requires age verification, or parental consent to access constitutionally protected speech. Instead, it gives parents and caregivers additional tools to keep their children safe online, including the ability to temporarily or permanently deactivate the child's account. I would like to turn it over to my witness at this time.
Before she speaks, we have a committee sub. We need to adopt that. Motion second. All right. All in favor say aye. Aye. All opposed, nay. Committee sub adopted. Please proceed.
My name is Jen. I am a homeschool mother of 5 children. Last year, one of my children began playing Minecraft and Roblox with several friends. Actually, 3 of my children played these games. But one of my children, while playing Roblox in particular, somehow had a grown man enter his friend group. The rule of the house was you can never talk to anybody that we don't know online. We had multiple parental controls that always failed. We used NetNanny, BeSafe.com, Circle, Covenant Eyes, and then Evos is our latest one. At least with Evos, we could shut things off. My son, like many teenagers today, is pretty tech savvy, much more so than my generation. And somehow a man joined their friend group on either Roblox or Minecraft, or possibly both. We know for sure it was Roblox. Over about a 6-month period of time, this boy, who was a straight-A student, top-notch kid in every sport, organization, school, he did amazing, was becoming very depressed, had massive mood swings, difficulty sleeping, nightmares, and I'm sorry, he had emotional crises. He had suicidal thoughts. We ended up having to admit him to a psychiatric hospital for a week because he became so depressed. And during that time, we scoured his room and went through everything online that we thought was safe. And we discovered that there was a groomer that he was speaking to who was an older man and had convinced my son that they were in love, and my son needed to go to CPS and tell the CPS that our family was abusive and violent and hostile, so that he could be removed from the home and then could run away with this groomer. And my son actually attempted to do that. We also discovered that they had exchanged phone numbers, and my son even took pictures of our property and sent them to this person. The day that he came back from the hospital, 5:30 in the morning, a car showed up in our driveway, and we panicked. And I saw a person getting in the car and thought for a moment it was my son, and it was a moment of total havoc and panic. We ran down the hall to see if he was still in his bed. Thank God he was still there sleeping, and it was just an Amazon man. But our whole family has been completely traumatized by this because my son could have disappeared. This groomer is in another state. If I was not a homeschool mom, I think my son would be gone because there would have been no one there to see what he was doing. If he was in school full-time, or if I was working full-time, we would have never discovered all the things that we were discovering with him. The only way to protect our son at this point was to shut off the internet completely. We pulled him out of all of his co-ops and his social groups until we can just work with him. We took him to counseling, and his counselor told us that only my son would know how he feels, and if he's in love with this older man, that's his truth. So we pulled him out and discovered that this counselor had given him a safety sheet. So if he should have another emotional crisis, he could call these people on the safety sheet. And guess who the number one number was? This groomer. So if my son were to have an emotional crisis, his counselor had him call this groomer and possibly, be sold into human trafficking, be a sex slave at the age of 16.
I think the one part that you left out that I want you all to hear is that they met on a gaming website, but then there was communication to go to a different website where they could take it offline. And that's where the conversation continued. And so I think that's what's important for this committee to also understand, that it's, I've been approached and I've held very firm because people wanted to be excluded from this legislation that we drafted. And I felt that for me, games is where this starts with young children, and that was shown to me when we started talking, and that they convinced them then to go offline. So if there are no questions.
We have a motion and a second, but we do have some questions. First is Representative Roberts.
Thank you, Chairman. Thank you, Representative Dietz, for bringing this bill. I do have one question. Can you explain to me, maybe I'm just missing it in my scan of the bill here, are there any penalties for violations built into this legislation?
Sorry, I want to make sure I have the bill in front of me. We've met with the Attorney General's office, and there is the Attorney General enforcement, and that's at the end of the legislation. I think it may be on the last page. It does not give a private right of action. Oh, page 9 of 10 of the bill, line 24.
Thank you. One question of clarification. So based on that, there's no additional or more specified penalties that are built in here. It's just under the purview of the Attorney General.
That's correct.
Okay. Thank you for answering the question. Thank you.
Representative Carney.
Thank you, Chairman, and I'd like to thank the sponsor for bringing this bill. I'd like to thank you, ma'am, for your testimony here today. I did have a quick question, Representative, if you could just explain what the differences in the committee sub, or what was changed, just very briefly.
The committee sub, I think it had the
It's the severability clause. The severability clause was originally in bold and underlined language, and instead it needed to be in non-codified language, so it was just a drafting issue from statute revision. And so it's the very last paragraph that is now non-codified language.
And that's the only change?
Yes,
okay.
ma'am.
One brief follow-up, Mr. Chairman. I think this is a very important piece of legislation. I appreciate that you didn't want to do carve-outs and exemptions and things to dilute the basic impact of this legislation. I was curious, you had mentioned in your explanation of the bill that this allowed for the deletion, I guess the downloading and the deletion of a user's profile, or just anything that was online. I wondered if you could just go into that a little bit more. And the reason I'm asking is because, you know, this kind of thing, this vulnerability happens to a lot of our kids, especially to the ones that are the most marginalized. And so who may not have an open line of communication with parents, for instance, or they may not be able to be as on top of their online activity as you were. So my question is, how logistically would that work? And how responsive do these companies need to be?
So I think we left this pretty vague for the companies to come up. We've directed them what needs to happen, and the companies are going to need to come up with a way to handle that. We reviewed all of the different pieces of legislation that have been passed across the country. Nearly all of them are in litigation at this point. None of them have gone completely through litigation. So we wanted to be sensitive, and we looked at what the lawsuits were and what they were bringing those on. So we felt that leaving this vague for the companies to come up with their own ways to handle this, we thought that would be a better method in this bill.
Thank you.
Representative Maddox.
Thank you, Mr. Chairman. Thank you, Representative Dietz, for bringing this bill, as well as the mother who is co-presenting with you. I can't imagine what that must have been like for you and your family to deal with, and I'm deeply sorry that you were impacted by such a sick individual and circumstance. I'm a firm believer in not offering criticism if you don't have a suggestion or an idea to improve it. So please don't interpret my question as any type of criticism of your legislation. I'm just curious about the age verification component of it, and I wanted to hear, for my benefit, but also for the benefit of the committee, what your thought process was, knowing that kids under 18 could just go in and put a different birth date or something along those lines. I think you maybe briefly alluded to it a moment ago, the idea that parents have the ability to provide them with that knowledge, which they then have to deal with the fact that they have been informed. So, perhaps that is one aspect of this that's very relevant, but I just wanted to hear your rationale on the age verification component. Thank you.
So there were two pieces that I struggled with. And the bill drafters here, and I probably drove him crazy because I would ask him to put it in and I'd ask him to take it out. And part of it was consent at the front end, and the other is the age verification. And this went to us, again, reviewing all of the litigation that's occurred so far across the country. It felt that if we had it as a known minor, and, when they log on to a website and they put in their age, if they put the wrong age in, so they put in their 13, and they want to go back and correct it, they're not going to be able to correct that without an adult. Yes, there's going to be savvy, as she said, much savvier than I am or other parents, and they're going to be able to, put in I'm 19, 20, or 21. I didn't see that there was any way for us to be able to have that where it wasn't going to be legally challenged. So that's in looking through all the litigation, we felt that this was the best way to possibly handle it.
Thank you.
We all got a motion. All right. I see no more questions. Sasha, please call the roll.
Representative Dotson?
Yes.
Representative Pfister?
Yes.
Representative Freeland? Representative Grossberg?
Permission to explain my vote, Mr. Chairman?
Yes.
I'm a yes on this. I'm of the generation that before there was a term for social media, we were on America Online before it was even connected to other outside servers, and you couldn't email back and forth. And when the chat feature first came out, you never knew who was on the other end of it. And I think everyone who, like myself, was a preteen at the time got those uncomfortable messages asking additional questions, wanting photos. Being of that generation, we are the generation that first had gaming that connected to the internet, and there were no regulations out there. So I'm glad that for the succeeding generation, we're making a good faith effort. I just hope that the general public understands that because this is new territory, this bill is not perfect. I don't know what errors or flaws may exist, but we will learn those in the upcoming years. So I just ask the public for patience as we codify this and adjust as necessary. But I thank the sponsor, and I thank you, ma'am, for sharing your story. And thank God that it wasn't worse. I'm sorry that you went through that, but I hope that this legislation prevents others from enduring what your family did.
Representative Heath?
Yes.
Representative King?
Yes, ma'am.
Representative Kulkarni?
Briefly explain. I'm a yes. I support this legislation. I am hopeful that in future, maybe as a result of whatever outcomes these nationwide litigation outcomes that may occur in the future, that we are able to come back and revisit this issue to strengthen the requirements and the enforcement of some of this from these companies and not just leave it up to them. I completely understand legally and why this needs to be a first step, but I'm hopeful, given the intent that you've purported and the urgent need for it, that we can come back and revisit some of this in the future. Thank you. I'm a yes for today.
Representative Lawrence?
Yes.
Representative Maddox? Yes. Representative Roberts? Yes. Representative Stalker?
Explain my vote, please. I am also a yes today, and I too would like to see us find some ways to strengthen this legislation in particular. And what I also want to be careful about, and I did not ask this question, but it did go through my mind, understanding what the age gap really is for some of our users. So I understand that once folks get to be 18, they are legally an adult, and that communicating with somebody younger than obviously 18 poses a problem legally. So I'd like us just to be able to come back at a later point and address some of those, what could be very small differences in ages for future situations, not necessarily specific to this, because this sounds quite horrendous, and I'm really sorry for what you and your family had to go through.
Thank you.
Representative Tate?
Yes.
Representative White? Yes. Representative Witten?
Yes.
Chairman Pratt?
Yes. House Bill 463 is amended, passes with favorable expression. The same should also pass on the floor. Thank you guys for your testimony today.
Thank you.
I'm going to give up the chair at this point in time and go present. Co-Chair Lawrence, will you please conduct?
Representative, if you'll come to the table and introduce yourself for the record.
Philip Pratt, State Representative, 62nd District.
Representative, we do have a committee sub on this. Would you like to explain that?
Basically, this was a language that Kentucky Justice Association would like to have. That's all it does, is actually move the statute of limitations from 5 years to 3 years. This was language they wanted, and actually several other people wanted. That's all it does.
Motion on the sub.
We have a motion and a second. All in favor, please signify by saying aye. Any opposed? Committee sub is adopted. You may proceed.
Thank you, Mr. Chair and members of the committee. House Bill 400. The problem, the Kentucky Wage and Hour Act, which is codified in KRS Chapter 337, contains numerous wage hour requirements that go beyond what is required by its federal counterpart, the Fair Labor Standard Act of 1938. FSLA as 1930 as amended. These discrepancies create confusion for employers in Kentucky who must ensure compliance with KWHA as well as FLSA. The dual compliance challenge for employers is specifically difficult for those businesses that employ workers in multiple states. The solution, House Bill 500, will modernize KWHA so that it more closely tracks with its federal counterpart. This bill makes the following substantive changes to existing law. Eliminate the seventh day overtime provision, which requires time and a half wages for hours worked on the seventh day of the week. Kentucky and California are the only two states that still have this requirement. Basically what this means is if you're working, example, 2 to 3 hours a day, on the sixth day you don't pay overtime. But on the seventh day, you still have to pay overtime even though you have not hit 40 hours. Basically it says you get overtime when you hit 40 hours. It's not so many days, it's when you hit 40 hours. Reduce the statute of limitation period for bringing a lawsuit from the current 5-year period to mirror the FSLA's 3-year period. 3 years, not 2 years, was a change requested by KJA. Eliminate the requirement that employees must give a 10-minute paid rest breaks for each 4-hour period work. Kentucky is only one of a handful that still require employers to give adult employees paid rest periods for adult employees. Under 18, you have to. Others include Maine, Minnesota, Nevada, Oregon, and Washington. Now, don't get me wrong. If you want to offer an employee a 10-minute break period, you still can. It's just not required. And we're just a handful of states still do that. Eliminate the requirement employees must provide a 30-minute unpaid lunch period for adult employees near the midpoint of their shift. Replace it with FLSA's approach. There is no requirement to provide lunch period for an adult employee, but if an employer chooses to provide the lunch period without pay, the employee must be completely relieved from the duties at this time. Right now, your employer can say, we're giving you a 30-minute lunch break that's unpaid, and guess what? You still got to sit at your desk, answer the phone. You still got to do your job. You still have to do this. This actually says if you get a 30-minute lunch break unpaid, then you actually must be relieved from your position. Right now, they can actually require you to work, and there's nothing you can do about it. There are actually 30 states that actually have the same existing language. This bill also provides clarity on several issues that have been subject of recent court cases. Create a new section adopts the portal-to-portal language for the FLSA, specifically 29 U.S.C. 254, which draws a clear line to separate those activities which are compensatable under law and those activities which are not compensatable. Last year in Hughes versus UPS Supply Chain Solutions, Inc., the Kentucky Supreme Court ruled by a 4-3 decision that Kentucky's Wage and Hour Act simply incorporates its provision by federal law. But 3 justices, dissenting from the court's opinion, criticized the majority's reason in part by pointing out the Kentucky General Assembly had never explicitly adopted this language. With future changes in the membership of the Supreme Court, a future 4-justice majority might reverse the decision in Hughes. House Bill 500 will foreclose that possibility, making it clear that KWHA is supposed to be interpreted consistent with federal law on the specific issue, ratifying the conclusion of the 4-justice majority in the Hughes decision last year. Basically, what this says is, if you drive your company truck home, we're not going to pay you to drive that company truck home. When you drive back to work, you do not get paid to drive that company truck back to work. Now, we're going to hear that, you're going to worry about people that work in HVAC or has protective equipment. Your time starts when you hit that door. Your time starts when HVAC, when you hit the door. If you drive the job to job, you still get paid. It just basically says you're not going to get paid to drive back and forth to work using a company vehicle. Clarify what kinds of damages are available in retaliation lawsuit against employer who retaliates an employee for asserting his or her rights in KWHA. And this was the law before, it's going to be the law afterward. Economic damages, an equal amount to liquidation damages, and award of attorney's fees and costs. Prior to House Bill 500, the courts construed existing KWHA in the same manner. See Williams v. King v. Delivery, LLC, 199. Make clear the punitive damages are not available for a KWHA lawsuit, codifying the same conclusion by a federal court in 2016. That retaliation claims brought under the KWHA do not permit an award of punitive damages. Williams v. King v. Delivery, LLC. The plain language of the statute does not permit an award of punitive damage to a plaintiff. However, the bill keeps the triple damages component in existing law for extreme cases, for rare cases of forced labor or compulsory labor. So again, remember, this has nothing to do with putting on a protective equipment when you get to your job site. If it's required, the second you hit the door, your time starts. It has nothing to do with that. It also has always been, by the way, agriculture is exempt from this bill. It always has and always will be. That's my testimony, sir. If you have questions, I'll be glad to answer them.
Motion on the bill.
We do have a couple people signed up to speak on the bill. So is any of the questions directed directly to Representative Pratt?
Yes.
Okay, we do have one question for you while you're there.
Yes. Thank you, Mr. Chair. I got a couple of quick concerns that I just want to address, and I do appreciate the intent of the bill, and I know what you're trying to do here, but I can also see some unintended consequences. For instance, some job opportunities pay travel time, per diem, things of that nature. I can see emergency responders going to lunch and get a call and have to go put out a fire and have to go. So I can see that there could be situations where this would absolutely hurt maybe our first responders, hurt our police officers. If we see unintended consequences going forward, and we're starting to hear more feedback from other stakeholders, would we be willing to maybe do another carve out or to be able to address those?
Absolutely. We do not want to affect our first responders at all. That's not the intent of this bill.
I know that.
And like I said, again, they're already carved out in this bill. This does not affect them. Again, it only comes into play for lunch hour if the employer looks at you and says, oh, by the way, you got to take a lunch hour and it's unpaid, but you got to work.
Right.
That's when this bill comes into play.
Right. Quick follow-up.
You may.
So you'd be willing to sit down and look at some of those issues that are potential things that we would have to face?
Absolutely.
Amen. Thank you so much. I appreciate it.
We do have one other question. Representative Roberts.
Thank you, Chairman. Representative Pratt, could you help me understand who's asking for this bill and what experts you consulted in the drafting of this bill?
Actually, I talked to people, like actually being a small business owner, trying to navigate the federal, state labor standards is a nightmare already, and this, again, it's been that way for a long time. So this is actually what drove this bill, is the fact that you have federal law, which says you must do this. Then you have state law says you got to do that. And to run afoul of them becomes very easily, very unintentionally, because the fact there are two different standards that employer must work under. So basically what this does, this moves this right almost equal to the federal labor standards so that we actually can navigate that system a whole lot easier.
Follow up, if I may?
You may.
I don't believe you answered my question. What I heard you say is that you filed this bill for yourself and your business and your concerns about running your business. My second part of the question was, what experts did you consult? Labor cabinet, workers groups, labor unions, your own employees about what might be helpful to them?
Actually, I resent the fact you made that I did it for my company. We always will give a 10-minute break. We always will give a paid lunch break, not paid, unpaid, and they will get to take it off. I did it because of businesses in Kentucky to help them, not myself. But no, I did not talk with the Labor Cabinet. Actually, I'm glad you brought up the Labor Cabinet. This bill was filed on February the 9th. It was actually assigned to committee, I believe, on the 26th. Last night at 4:45 p.m., I got an email from them asking to meet with me about this bill today. Just a tad bit short notice.
Thank you. I'm hoping that one of the people that's about to come up and speak is the Labor Cabinet. I also think it's incumbent upon us as lawmakers to reach out to the experts in the bills that we're drafting, not to fully expect them to come to us every time. Thank you.
I'm not sure we let bureaucrats make the rules when we are the lawmakers.
All right. With that, we're going to allow, I believe it's Gerald Adkins. If you would come to the table, please, and introduce yourself for the record, and you may proceed.
I also have another gentleman, Dustin Pugel. Is that okay if he comes with me?
Okay. All right. That'll be fine. Just introduce both of yourselves. Make sure when you pull your mics up to you, hit the button and make sure green light's on.
Good afternoon. I'll pull it a little bit closer. Good afternoon, Vice Chair Lawrence and members of the committee. Thank you very much for allowing me to testify this afternoon. My testimony will be very brief. My name is Gerald Adkins, and I own a small business with employees, Working Strategies 2 LLC. Today, I am testifying as a legislative agent for the Kentucky State AFL-CIO and the Kentucky State Building and Construction Trades Council. There's 100,000 members in the AFL and 20,000 members in the Kentucky State Building and Construction Trades Council. Not only will this bill impact all of our members, but it would be devastating to all workers in the Commonwealth of Kentucky. I am able to speak on this bill today from a personal standpoint, as I worked my career at the Division of Employment Standards in the Kentucky Labor Cabinet. I supervised the Wage and Hour Division for the last 15 years of my career. I have significant knowledge of the impacts of overworked employees, including low employee morale, increased injuries in the workplace, and high turnover rates. This bill, if passed in its current form, would repeal Kentucky's rest periods, lunch breaks, and seventh-day overtime laws, and eliminate overtime and minimum wage protections for activities such as travel time between job sites and donning and doffing of protective gear. These laws have been in place since 1958, 1974, and 1942, respectively. Why the sudden urgency to repeal laws that are in place to protect Kentucky's workers? I have talked with many of you on this committee in the last couple of days about our concerns with House Bill 500 and are asking that you vote no today on House Bill 500 Committee Sub 1. I will end my testimony now and let the other folks who are here to testify to speak on the repercussions of this bill. I have talked with many of you on this committee in the last couple of days, and I hope that you will vote no today. Thank you, Vice Chair Lawrence and members of the committee, for allowing me to testify this morning, and I would be available for any questions if you have any.
Good morning. My name is Dustin Pugel. I'm with the Kentucky Center for Economic Policy. Vice Chair Lawrence, members of the committee, thank you for giving me a moment to testify on House Bill 500. As written, we believe House Bill 500 would take away Kentucky workers' rights under law to take breaks at work and would eliminate pay protections such as overtime for 7-day work schedules and minimum wage requirements for time spent traveling to and from a job site. It's a sea change to long-standing basic rights and dignities on the job that will harm practically all Kentucky workers. For example, currently, businesses must provide a meal break every 3 to 5 hours, but this mandate, which was created in 1974, is eliminated by Section 15 of the bill. House Bill 500 leaves it to the employer to decide if they will provide an unpaid lunch break or force workers to juggle eating while on the job. Consider a nurse, for example, in a hospital that tells her she must work her full shift straight through with no breaks to eat. House Bill 500 would be asking her to try and eat while providing medical care to patients or not eat at all. If the employer does provide a lunch period and they discover that a worker is eating at another time while on the clock, Section 3 says they won't be required to pay their employees for that time, even if a worker is taking a snack break for medical reasons like diabetes. Additionally, at present, employers must provide at least a 10-minute work rest period for every 4 hours of work in addition to a scheduled lunch period. House Bill 500 repeals that requirement. These breaks are important for every worker, but especially in jobs with high physical intensity or in hot locations like a warehouse or a roof. Right now, state law encourages employers to give employees some downtime each week to rest, to recover, to spend time with their families, by entitling employees who work 7 days in a row to receive time and a half overpay. But House Bill 500 repeals that as well. But then House Bill 500 goes even further by eliminating employer liability for failure to provide overtime or even minimum wage for workers in time spent traveling between job sites. In other words, an HVAC repairman or a landscaping crew could get paid as little as a penny per hour for time spent driving between houses, and the state law would have no way of holding employers accountable for that. The same lack of protections would apply to an employee who has to take necessary steps to prepare each day for a day of work or transition at the end of a shift. For example, a firefighter that has to put on protective gear, or a factory employee that has to put on a hazmat suit before working with dangerous chemicals such as paint, would not have minimum wage or overtime protections for the time that it takes them to change into and out of that equipment each day. Even consider a bus driver who must check the condition of their bus before picking up school children each day. They would be left without minimum wage or overtime protections in this bill. Finally, it leaves employees who have been the victims of unfair employment practices with less time to seek accountability, as House Bill 500 decreases the statute of limitations for some labor violations from 5 years to 3. The bill also bans punitive damages for employees who experience emotional distress, humiliation, or embarrassment while being wrongly discharged from their job. Collectively, these provisions weaken multiple common sense protections for safe working conditions and fair pay that have safeguarded Kentuckians for at least a half a century. We as a state put these protections in place for a reason, and those reasons have not changed since then. Repealing these guardrails will make work more dangerous by depriving workers of time for food and rest, incentivizing them to travel too quickly to get to their job sites, and discouraging them from taking proper precautions at the beginning of a shift. And it will take pay away from workers when they are traveling between job locations, working all week long, 7 days in a row, and putting on and off equipment necessary to do a job well. Put simply, House Bill 500 makes Kentucky a worse place to work. I appreciate your consideration, and I ask that you keep these important protections for hardworking Kentuckians' well-being and their pay.
Thank you, gentlemen. We do have a couple questions if you'll hold up just a second. Representative Roberts.
Out of practice. Thank you, gentlemen. I really appreciate your being here to discuss this today. I don't think of either of you as being bureaucrats. I think of both of you as being experts in your field. So I appreciate that you would be here today to give us the feedback that I think is really necessary on this very impactful piece of legislation. I read this the same way you do, both of you stated, about the traveling from place to place as far as workers go. Can either of you talk to us about how many hours you might think that would take out of someone's pay over the course of, I don't know, a week, a month, a year, what the financial burden might be to workers?
I won't be able to give any of the exact figures, but I can give you some guesstimates. It can be significant for certain types of workers. For example, if you have a refrigeration company that travels from client to client during the day and they're going from one house to the next house, that takes the ability for that employer to no longer have to pay for that time. You could have in the first responder industry, if they're transporting a patient from a house to a hospital, that would be considered travel time. They would be in the employer's piece of equipment, their vehicle, and this would no longer have to be compensated as hours worked. So that could be significant, especially over in the mountains of eastern Kentucky. For you all from over there, there's no hospitals in certain areas, and it's a lengthy travel.
All right. With that, thank you, gentlemen. If you guys will just exit the podium there for a moment. We have Dwayne. Are you with us? Okay. If you'll come up and introduce yourself and your guest for the record, you may proceed.
My name is Dwayne Hammonds, and I am the Director of Wage and Hour for the Division of Wage and Hours for the Department of Workplace Standards in the Education and Labor Cabinet. I'll let my guests introduce themselves.
I'm Jessica Williamson. I'm General Counsel with the Education and Labor Cabinet.
Chairman, members of the committee, my name is Jordan Jones. I'm the Legislative Director for the Education and Labor Cabinet.
I would first like to thank Vice Chair Lawrence for allowing us to speak on this matter and the committee for hearing our comments. House Bill 500 poses significant concerns regarding the potential erosion and critical workplace standards, which could have detrimental effects on employees across the state. The bill eliminates wage and hour protections for Kentucky workers, rest break laws, which has been in effect since 1958, mealtime break laws, which has been in effect since 1974, and seventh day overtime, which has been in effect since 1942. This protects employees who currently are exempt from overtime because of other statutes. These decade-long standards we have are in place for our safety, mental, and physical health of all Kentucky workers. Elimination of travel time. The House Bill 500 mandates that an employer face no liability or punishment for not paying an employee wages or overtime for traveling to and from the actual place where the employee is to perform the principal work activity. This significantly reduces the protections for employees during travel time that is required to perform the work. For example, employers would have no liability for not paying employees who must travel to several locations for work, such as HVAC, repair work, plumbers, electricians, landscapers, construction workers, etc. Any preliminary work-related activities would not be considered hours worked or payable time, even when mandated by the employer, such as donning and doffing. The time spent putting on PPE for the safety of that employee would not be considered hours worked. Meal times and breaks. House Bill 500 would erase the statute requiring employers to give their employees a reasonable period for lunch and setting the time parameters for that lunch. Generally, House Bill 500 would eliminate breaks overall as payable hours for all Kentucky employees. Paid breaks and meal times are essential workplace standards that contribute to the mental and physical well-being of each and every employee we have in this Commonwealth. Seventh day overtime. There's been several comments on that. House Bill 500 also removes the ability for the Division of Wages and Hours to hold employers accountable for violating rest break protections and limits the ability to enforce that seventh day overtime law. The bill completely removes the statute requiring the employers pay employees overtime for working on the seventh day of a work week, erasing the long-standing protection and reducing workers' pay. This is a protection that we afford to employees who are exempt from the current 337-285 overtime statute. House Bill 500 makes specific occupations no longer exempt from wage and hour requirements under Kentucky law, such as record keeping and posting of summaries of wage and hour laws, orders and regulations. This means that certain employers will have burdensome records that they are required to keep that they have not been required to keep to date on certain types of employees. They will be required to keep detailed time and attendance records not previously required before this House bill. Thank you.
Thank you. Are your guests going to speak? Okay. All right. Are there any questions? Representative Kulkarni.
Thank you, Mr. Chair. I have a few questions that were raised by some of the testimony that you gave. Specifically, what impact do you think the removal of these wage and hour protections would have on workers' comp claims?
I think that's a little bit outside the scope of what we're here to talk about and what the subject matter expert could speak on. That would be something we'd have to look into further.
Okay, one brief follow-up.
You may.
Would you all be able to speak to the meal breaks, for instance? If this legislation and removing those meal breaks would somehow conflict with the ADA or individuals with disabilities or medical conditions that have to eat at certain times, how would that be impacted by this legislation?
As far as the legal impact of how those might conflict, there may be a potential for that, but we would need to look into that in more detail.
Okay, thank you.
With that, because of time restraints, I'm going to ask Representative Pratt to please come back to the table. Thank you guys for your presentation. We do have a question for Representative Pratt. It'd be Representative Stalker. If you could keep it brief, we're going to try to move along.
Thank you, Chair. Sponsor, my first question is why are we reducing the statute of limitations for the violations of labor laws from 5 to 3 years?
Actually, they were confusing. Some were 2, some were 3, some were 5. This is something actually the Chamber and actually the Kentucky Justice Association would like to have. That way they have consistency. That's the only reason we did that.
Is it safe to say you consulted with them regarding that?
Actually, they came to me.
Okay, so yes, there was consulting. Thank you. Follow-up question, please?
You may.
I'm curious how weakening labor standards like this will help attract workers to Kentucky and how it actually helps our employers also attract employees.
Again, I don't know if it's about attracting employees. I think what you're looking at is employers trying to follow the state law, which is one thing, federal law, which is another thing. We're trying to, and especially imagine this, if you had a company that worked in several states trying to keep up with those, it's trying to keep companies from running afoul of these laws and wind up getting fined. That's all we're trying to accomplish. And again, we're just trying to make Kentucky's law mirror much more closely the federal law as it reads currently today.
Follow-up question for clarity, if I may.
One more.
So you just said that you would like, this is about following and mirroring federal law, but it is my impression that federal law is $7.25 an hour, and that is what Kentucky currently has as minimum wage. So it feels like we're already at the bottom. We're one of many states that has not taken the initiative. Unfortunately, there were several failed attempts in the past to raise our minimum wage, and that has not happened. So we are already at the bottom. We're at the floor. How your bill, though, is allowing us to go lower than the floor?
No, we cannot do that. The federal law is federal law, and if it is, that's a typo. But no, the minimum wage is minimum wage. And I'll be honest, anyone that's paying minimum wage right now is not getting an employee. I can tell you that. I mean, you're just not going to find one. So I would say the minimum wage is easily $12.50 or above. And I can tell you, at my company, we start at $15.46 an hour and go from there.
Next, we have Representative Roberts.
Thank you. Representative, I guess my question right now is on the overtime portion of this and why you put that in there. And I think to my region, Northern Kentucky, which has a real shortage of emergency providers right now, both police and fire. And the way that we're addressing that is we're having to have those folks work a lot of overtime right now. It's hard enough to ask these folks to take more time away from their families, to put themselves at more risk for their communities. So can you help me understand how saying they're no longer eligible if they've worked more than 7 days in a row is going to help us with this ongoing problem we have in this state?
Actually, again, my explanation is you will get paid overtime once you hit 40 hours. If you hit that in 3 days, you get paid overtime. If you hit it in 7 days, you get overtime. Basically, all it says is if you only work 2 to 3 hours a day and you don't hit 40 on Sunday, you don't, well, whatever that 7th day is, you don't have to pay overtime till they hit 40 hours.
Another, please.
You may.
Your answer concerns me because of the way Kelly shifts work and the hours that first responders and police officers work. So I think there's an oversight there that could be very concerning and could lead to us having fewer police and firefighters available to our communities. The Labor Cabinet also said in their testimony that they feel like the provisions in this bill would actually create more headaches for business owners. That was concerning to me because it was contrary from what you said. I think rather than a question, if I will, I'll wrap it up. I understand we're limited on time. Although I will say, just as a broad statement, I think we should spend more time on this issue than the unpaid lunch hours that we're now going to have for our constituents. I will say to my colleagues on this committee, what this is doing is asking our constituents to work harder and longer for less pay. That less pay will lead to less payroll taxes. It might lead to more errors in things like really complicated jobs, like and stressful jobs like social workers and nurses and emergency professionals. I think this is a very, very dangerous piece of legislation. I think it is absolutely employee and Kentuckian unfriendly, and I urge everyone on this committee to vote no for their constituents and the workers in their districts.
May I respond?
Absolutely.
You know, again, I may be more confused. I don't understand when you say first responders, policemen. When you get 40 hours, you get overtime. That's plain and simple. So if they're only working an hour a day, I don't know if policemen or any first responders work 1 or 2 hours a day. I mean, I don't understand that. But again, once you hit 40 hours, you get overtime. Again, it's only for people who work part-time, you know, again, whatever number you want to, and they still haven't hit 40 on the 7 until the 7, you know, in that's what it comes down to. You know, again, I've heard a lot about lunch breaks. It doesn't say you can't get it. It just says if you tell an employee you get a unpaid lunch break, you have to be relieved of your duties. I think you'd be all over that. Also, you know, again, you've heard that about the protective gear. It plainly says, this bill has nothing to do with that. The second you hit the door of your employer, you get paid. Then that means when you walk in that door, you're getting paid, then you put on protective gear, then you go to work. No, that does not work at all. And actually, I heard someone say nurses, again, I'm glad you brought that up. As two sons that are nurses, I can tell you got nurses right now in hospitals that are eating, standing up because they don't get a lunch break right now. This says if that's unpaid, they have to be relieved. I can tell you, both my sons will tell you, it's not unusual for them not to get a lunch break. They eat right through it because that's the workload they have to have. You know, again, some of this, like I said, and punitive damages. I heard that said also. Punitive damage was never offered before. It's still not. Wood is clearly saying punitive damage is not part of this. That has nothing to do with it. And again, I've heard also that if you were doing HVAC and you're driving from house to house, you wouldn't get paid. Horse hockey. When you show up at that place of work, you get paid till you go home, until you leave that last stop and go home. And like at Pratt's Lawn Landscape, my employees report to my office, then they get their equipment, then they go out, they get paid till they show back up the doorstep. Same thing with every business I've ever talked to. That's ridiculous. So again, and again, like I said, you talked about ADA, that's a federal law, and I will remind everybody on this committee, you cannot trump federal law. Also, anybody on this committee has went to a conference, did you get paid driving to it? No. You got paid the day the conference started. The day the conference over, you get to drive home unpaid. That's what this bill says. You don't get paid driving to something. You get paid when you're actually working.
With that, we do have a motion on the bill by Representative Pfister and a second by Heath. We're going to go ahead and call the roll. Sasha, if you'll do so.
Representative Dotson.
I'd like to explain my vote. Thank you, Chairman Pratt, and I appreciate the willingness that you expressed to be able to work on the bill. I do see some unintended consequences again, and after meeting with stakeholders, but I will vote yes today to get it out of committee, and let's work on it to make it a better bill, and I appreciate that. Thank you.
Thanks, sir.
Representative Pfister.
Yes.
Representative Freeland. Representative Grossberg.
Permission to explain my vote briefly?
Very briefly, please.
I'm a no on this because apparently organized labor and the labor cabinet are reading so much of this bill differently. For example, the subject line on Section 2 that no employer shall be subject to any liability or punishment under this chapter for failure to pay an employee minimum wages or pay an employee overtime compensation. So we have a conflict between what the sponsor says it is and what the experts say it is. This bill, I think, deleteriously affects lunch breaks, travel time, donning and doffing, and I think it's going to worsen the labor shortage that we already have in Kentucky. And I'm not comfortable with us ceding this local control over how we handle labor to federal standards only. So I'm a no on this.
Representative Heath.
Explain my yes vote.
You may.
I find it interesting that Kentucky and California are the only two states left that haven't already lined up with federal law, and they seem to be operating fine. We just heard from the chamber member how we were losing people to Tennessee, and Tennessee has already lined up with federal law. It just seems like there's a lot of confusion surrounding this. I'm a yes vote.
Representative King.
Yes, ma'am.
Representative Kulkarni.
Briefly explain, Chairman.
You may.
I'll be a no today, and there are many reasons that have been heard. I am very concerned about the unintended consequences, as my colleague mentioned, because the people that this is going to impact the most are entire industry sectors that do not stay in one place and have to drive around all day. We're talking about emergency responders, we're talking about firefighters, we're talking about HVAC, we're talking about a lot of groups that are going maybe to a central location to pick up a van, pick up equipment, or equipment, personal protective equipment, and then go out and are out all day. Mm-hmm. So rather than, talking about how this is gonna help people take meal breaks, what it's actually doing is making them get paid less. They have to eat, they have to be out. They're not going to be able to do that under this legislation. They will be unpaid. They will be unpaid, and that's mandated. My concern is that nurses, first responders, emergency responders are some of the most necessary and crucial workers. We've been talking about workforce shortages for years. It is unclear to me why we would take away protections, why we would take away periods of protection where employers are not liable for payment, not liable for perhaps injuries on the job, not liable for anything in certain periods of time. I think as a whole, this bill is not necessary for the cost savings, I'm assuming, to a small business owner. These laws were put in place decades ago to protect workers, and the more that we erode worker protections, the harder it is for us to get people in those jobs. We're already taking away their incentives. I apologize. I'm a no for today, but I think there's, as I'm, obviously rambling on about, a lot of reasons why this will actually hurt small businesses because it will not help them get the employees that they so desperately need.
Representative Lawrence.
Yes.
Representative Maddox.
Mr. Chairman, may I briefly explain my vote?
Very briefly.
Very briefly. Thank you, Mr. Chairman. Thank you, Chairman Pratt, as well, for bringing this legislation. But I am going to vote yes today. But there are questions that have occurred to me just in the context of this meeting that has taken place today, even as recently as some of the vote explanations are creating more questions that I have about this, particularly with regard to workers' compensation. So I'm going to be asking you those questions. I didn't want to put you on the spot or any of the other folks who have testified in opposition to this bill by asking these questions, but I definitely want to learn more about what we're voting on and see if any changes need to be made. Thank you.
Representative Roberts.
No.
Representative Stalker.
Briefly explain my vote.
You may.
Thank you. I am a no today. I don't see the need for this bill. I don't think it's going to do anything positive. What I am interested in doing is working with you, if you were interested in doing that, as well as bringing some of the other stakeholders who did show up today to express their concerns. There's clearly a disconnect between the way this bill has been drafted and the intent, the way it reads from a legal perspective, and maybe what your intention was. And so if that is the case, I would like to sit down and make those corrections if this bill is going to proceed forward. But for today, I am a no.
Representative Tate?
Yes.
Representative White?
Concerns about it and lean towards a no on it, but I think there's a lot of this testimony was a little bit opposition is a little bit unfounded from what Representative Pratt intended, and I think it just needs some time here to get some questions cleared up, but I'm a yes on this.
Representative Whitten?
Explain my vote.
You may.
Thank you. I'm a pass today. Chairman, I appreciate the intent of this bill, and I understand what you're trying to do. I hear some unintended consequences, and I look forward to us figuring it out before it gets on the House floor, that we can make this work.
Chairman Pratt?
Yes.
Thank you, Chairman. Thank you, members of the committee. We are,
Mr. Chairman, real
House
fast.
Bill 500. I'm sorry.
Real fast.
Yes, you may.
Someone mentioned workman's comp in the comments. This has nothing to do with workman's comp. Nothing.
Thank you. House Bill 500 passes with favorable expression. The same shall